Hello everybody and welcome to History/Law Bite number 305, dated September the 5th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you for tuning in. This History/Law Bite is entitled Brown versus Board of Education of Topeka and Constitutional Originalism. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Juarez Lee Shelton M.A. In addition to that, please also click on the little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new and exciting videos in history, law, political science, theology, and philosophy. Thank you in advance. Again, this video is entitled Constitutional Originalism and the Brown versus Board of Education decision. Okay, this was one of my writings from back in 2018 that I'm simply converting over to video format. And I think you'll find it quite enjoyable, especially if you enjoy discussion involving constitutional interpretive philosophies, which of course include originalism, textualism, and the living document theory. Okay, so in this, I more or less argue the position that the Brown versus Board of Education of Topeka decision, which of course was a landmark U.S. Supreme Court decision in 1954, which found that racial segregation in public schools ran contrary to the language of the 14th Amendment requiring equal protection of the laws, in essence ruling public school segregation to be unconstitutional. I argue that this decision could have been based upon a more or less originalist interpretation of the 14th Amendment's Equal Protection Clause, okay, rather than the path that was taken, in which the Chief Justice utilized a more of a living document theory to bring it to life. Okay, so as I move along, you'll certainly find particular points of interest in this analysis. So without further ado, let's get to it. So we begin with the introduction. Constitutional originalism, essentially, if you've never heard of this before, is a legal philosophy whereby a judge or legal scholar interprets the Constitution's provisions according to their intent, all right, at the time of their drafting and adoption. So within the school of originalism, there are two distinct sects, all right? The first sect seeks out original intent. Okay, original intent theorists seek to discern the specific intent of the framers who drafted various constitutional provisions. Okay, whichever provision they happen to be interpreting here, they seek out the original intent of those who drafted the provisions. Okay, next, the smaller and less influential sect seeks out the original meaning, all right, from the Constitution. So these individuals, rather than dwelling on the intent of those who drafted the provisions, these individuals focus on the meaning of the Constitution's wording, as it would have been understood by the average individual of the time, okay, not just judges, lawyers, professors, and so forth and so on, but laymen, okay? Both are acceptable formats, all right, within the originalist school of thought. So that leads me to say that to the most orthodox originalists, however, using anything but the original intent of the lawmakers who drafted the provision, it is unacceptable, all right? So the orthodox originalists strictly adhere to the intent of those who drafted the provisions. not what it would have meant to the average Tom, Dick, or Harry at the time, all right? That's why I refer to them as orthodox, all right? Because what it would have meant to him and what it would have meant to her at the time could be totally different things. However, at least in theory, what it would have meant to the drafter is straightforward, okay? So, with that in mind, what the lawmakers sought to convey with the law to the orthodox originalists is what must prevail, okay? For that alone establishes the provision's true purpose, its true reach, and of course, its limitations, okay? Both sides, of course, have their limitations in the constitutional interpretive process, all right? However, to focus on what the law's perception would have been to the average individual of the day may not necessarily be what was meant by its author or authors. Both of these are in stark contrast to what I mentioned earlier, living constitutionalism, okay, which is an interpretive theory that the Constitution evolves, okay, its meaning evolves through time, all right, through the evolution of precedents and changing situations, all right. These individuals interpret the Constitution in a contemporary frame of reference. These individuals rarely look to the original intent or meaning of provisions with this format, all right, which, like I said, usually focuses on precedents and the present in formulating opinions based on those provisions. So this takes us to Brown versus Board of Education, cited as 347 U.S. 483, 1954. It is, of course, the landmark U.S. Supreme Court decision, which, like I said, declares segregation in public schools to be unconstitutional. Chief Justice Earl Warren based his unanimous opinion on a blend of living constitutionalism as well as socio-scientific evidence, ladies and gentlemen. That evidence was based on how segregation caused long-term psychological harm to black children with a stigma of inferiority. So while the evidence was a compelling sociology report, it was entirely unnecessary to make the case why segregation was unconstitutional under the 14th Amendment. So basically, this article will demonstrate why the U.S. Supreme Court, using solely an originalist interpretation of the 14th Amendment, could have declared public school segregation unconstitutional. All right? So we begin with the origins of the 14th Amendment. Remember, always have to have context. So the 14th Amendment to the United States Constitution had its origins in the Civil Rights Act of 1866. Designed to protect the civil rights of African Americans, primarily in the South, after the Civil War, but of course nationwide as a whole, part of the act read that, quote, all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other, end quote. So the legislation originally contained language regarding privileges and immunities, but this was deleted to appease more moderate Republicans over civil rights interpretation. That's would become ultimately the Privileges and Immunities Clause of the 14th Amendment, all right? But that was combined in the Civil Rights Bill at first, but that was later to be a separate clause of the 14th Amendment. No state shall make or enforce any law which shall bridge the privileges or immunities of citizens of the United States, Section 1 of the 14th Amendment, okay? But nonetheless, despite the omission, there was still clear evidence that many members of Congress wanted the law to be quite expansive, thereby ensuring full social equality for African Americans with whites. Though less provocative, many hoped that the courts would still interpret it to that effect, even with the watered-down language. So due to questioning over whether the Civil Rights Act of 1866 was constitutional, Congress incorporated most of its language into Section 1 of the newly proposed 14th Amendment to the Constitution. In their minds, this was the only way civil rights protections would be safe from future congressional majorities that would seek to repeal them, or, more specifically, shield it from judicial declarations of unconstitutionality. Very important thing. After intense debate over its wording, the 14th Amendment to the Constitution was passed by the Congress of the United States in June of 1866 and ratified in July of 1868. It contained 5 sections, longer than any other amendment before or since, all right? And it would affect Americans in radical ways never before seen. So, for the purpose of this article, we will focus on the first section of the 14th Amendment, which mirrors the Civil Rights Act of 1866, but is much more expansive in its language. It reads as follows, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." That's the Privileges or Immunities Clause. "Nor shall any state deprive any person of life, liberty, or property without due process of law." That is the Due Process Clause. "Nor deny to any person within its jurisdiction the equal protection of the laws." Last but not least, that's the Equal Protection Clause, ladies and gentlemen. End quote, by the way. So, worded very loosely and designed very broadly, this section of the 14th Amendment, in the minds of many, was crafted to leave no stone unturned. Okay? Citizens of all colors within the states were now to be protected on multiple levels without prejudice. Where the uniformity of legal and social equality comes from, obviously, is its Equal Protection Clause. Located at the end of Section 1, it reads, "No state shall deny to any person within its jurisdiction the equal protection of the laws." Equal protection of the laws, ladies and gentlemen. Based on that theory alone, if all are created equal, then no meaningful purpose exists to segregate anyone by means of race or otherwise. For sure, the clause had several very cunning and crafty architects committed to placing black Americans on the same legal and social footing as whites. Specifically, these crafty authors were none other than Representatives Thaddeus Stevens of Pennsylvania, John Bingham of Ohio, and Senator Jacob Howard of Michigan. All 3 of these men were members of the Republican Party. All of them believed the amendment to not only mandate legal equality, but social equality under the law as well. Many of these men had decorated histories in the anti-slavery movement and by similar virtue supporting equal rights for blacks. Keep in mind, many who were anti-slavery did not automatically support equal rights for blacks. Very important thing to remember. Many of them did, many of them did not. Thankfully, these 3 men not only talked the talk, but walked the walk. Not only did they hate slavery, but they also supported legal and social equality for African Americans, okay? So, indeed, the transcripts from the congressional debates of 1866 speak volumes of the intended purposes for Section 1, ladies and gentlemen. Representative Stevens, who was always outspoken in his advocacy, remarked, Section 1 allows Congress to correct the unjust legislation of the states, so far that the law which operates upon one man shall operate equally upon all. Whatever law punishes a white man for a crime shall punish the black man precisely in the same way and to the same degree. Whatever law protects the white man shall afford equal protection to the black man. End quote. Stevens emphasized the importance of having the law protect the black man in the same capacity as the white man. If that doesn't mean equality, I don't know what does, folks. Surely this was not to be limited based on any external factors, and thus included social equality along with legal equality. If the law enabled white citizens to something, black citizens were to have access to the exact same thing. No exceptions, exclusions, or separation of any kind. Among the crafters, among these three men, Stevens' life and history provide the most compelling evidence to his perspective on black equality in word and in deed. Because you know, a lot of people talk that talk, but didn't necessarily walk that walk. All right. His abolitionism and advocacy in the Congress before, during, and after the U.S. Civil War, as well as having a black companion, Lydia Hamilton Smith, until his death in 1868, his adoption of her two nephews, and his burial in one of Pennsylvania's only integrated cemeteries in that era, speak volumes about his convictions. Needless to say, none of those things gained him any accolades or high public ratings of any kind in his lifetime. Stevens died in August of 1868 at the age of 76. His gravestone reads as follows: "I repose in this quiet and secluded spot, not from any natural preference for solitude, but finding other cemeteries limited as to race by charter rules. I have chosen this that I might illustrate in my death the principles which I have advocated through a long life. Equality of man before his creator." So next, Representative John Bingham of Ohio, one of my personal favorites along with Stevens, who was one of the primary and most influential authors of the 14th Amendment, had similarly dedicated a great deal of his early life advocating for the equal rights of African Americans. This was both as an attorney and a congressman for the state of Ohio. All right. Despite its status as a northern free state, it was a place where blacks faced many legal disabilities compared to whites. Ohio had some very, very vicious black codes. Yes, black codes existed in the free states just as much as they did in the slave states. And despite its status as a northern free state, Ohio is definitely not a very friendly place for free African Americans. All right. And these black codes in the state were a factor in developing Bingham's attitude toward race relations as a whole. Reviewing his pre-congressional adult life, the 1830s through the 1850s, there is no record of him ever working against the interests of African Americans. Indeed, his strong egalitarian beliefs were not in unison with many of his fellow Ohioans, and each election cycle for Bingham proved to be a tough battle. He was not what you'd call a immune incumbent at any point in his career. He had worked tirelessly to secure the rights of blacks in Ohio, basic things like being able to testify against whites in court, all right, as well as to serve on juries, okay, well before the Civil War, and continued to do so after his election to the Congress. The 14th Amendment's first section proved to be a vindication of his life's work to that point, ensuring the equality of all Americans regardless of color. He lived until March of 1900, okay, long enough to see his amendment badly dismembered by the Supreme Court, most notably in the case of Plessy versus Ferguson in 1896. So that takes us to Senator Jacob Howard of Michigan. Senator Howard testified that the last two clauses of the first section of the amendment disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, or property, without due process of law, or from denying him the equal protection of the laws of the state. This abolishes all class legislation in the states and does away with the injustice of subjecting one caste of persons to a code not applicable to another. It will, if adopted by the states, forever disable every one of them from passing laws, trenching upon those fundamental rights and privileges which pertain to citizens of the United States and to all persons who may happen to be within their jurisdiction. It establishes equality before the law, and it gives to the humblest, the poorest, the most despised of the race the same rights and the same protection before the law as it gives the most powerful, the most wealthy, or the most haughty. That, sir, is Republican government as I understand it, and the only one which can claim the praise of a just government. End quote. So from this, we can strongly infer that Senator Howard's powerful words were not just rhetoric. So he sought to entirely eliminate all forms of class legislation, as well as destroy any caste of persons under the law. Thus, racial classifications were not to be permitted under Howard's analysis, as such things would maintain the very classes and castes within society he so strongly opposed. Howard sought to entirely restrain the power of the states in being able to discriminate against any group at any time for any reason. The only possible exception may well have been Native Americans who had chosen not to assimilate into mainstream society, as that group was still largely shunned by the states and the federal government. You know, and Native Americans had a very insecure legal status, especially if they chose to continue living on reservations as members of their respective First Nation communities and not assimilate into mainstream society. Regardless, however, Howard's opinion was non-negotiable, and, you know, it came with a full endorsement of social and legal equality for all people within a state's borders. All right. Lastly, Senator Luke Poland, Republican from Vermont, offered his belief on the type of society that the new amendment would create. He stated that the South will be opened and expanded by the influence of free labor and free institutions. All causes of discord between the North and the South being over, we shall become a homogeneous nation of freemen, dwelling together in peace and unity. End quote. Senator Poland's egalitarian statements using phrases such as homogeneous nation and dwelling together in peace and unity is an unquestionable statement in support of social equality between blacks and whites. All right, not just simply legal equality. To these men, the proposed 14th Amendment to the Constitution was to become a mighty engine of equality between individuals of all races in the states. In no way, folks, was it to be limited to being on a purely legal playing field. Therefore, one could make a strong legal argument based on the testimony from these senators that Section 1 of the 14th Amendment was clearly intended to facilitate both legal and social equality among the races in America. That takes us to the Brown case and originalism. So Brown versus Board of Education of Topeka, 1954, dealt head-on with the issue of racial segregation in America's public schools. All right, school segregation in the United States had been on the decline since the 1930s, well before Brown. But these were institutions of higher education, all right, thus adults, all right. So you want to learn more about that, see my videos on the cases of Gaines versus Canada, 1938. Sipel versus Board of Regents of the University of Oklahoma, 1948. Sweat versus Painter, 1950. And McLaurin versus Oklahoma State Regents, 1950. All right. These are all cases where the court ruled against segregation in higher education in various forms. Okay, I've done videos on all these cases if you want to check them out. So adult students, in the minds of many, could make their own choices about who they wanted to attend classes with. Thus, the tension over integration in higher education was substantially lower here. What made Brown, if you know anything about Brown, all right, what made Brown such an emotional case was that these were elementary school age children, young and vulnerable adolescents who were unable to make their own determinations. Many white Americans accepted the U.S. Supreme Court's decisions integrating higher education with little to no fuss. There was fuss, let's not get it twisted, but nowhere near the level of militant opposition that you would see with Brown, all right? Because, again, these were adults, so adults can make their own choices, all right? But when it came to mandating that their children attend classes with black students, however, all hell broke loose. And that's one of the mildest ways I could say it, all right? So to justify his unanimous opinion, Chief Justice Warren referenced and elaborated on the above precedents and buttressed it with 2 paragraphs of social scientific evidence to demonstrate just how harmful segregation was to young black students, young black children rather. This would be defended in the famous footnote 11 in the Brown opinion. In essence, the data by Dr. Clark showed how school segregation and its effects instilled upon young black children a badge of inferiority in comparison to white children, a badge of inferiority that they were never likely to grow out of. So for sure, the evidence in footnote 11 by Dr. John Henrik Clark was compelling, but no shade or disrespect to Dr. Clark or the Chief Justice, but it was unnecessary to put in the Brown opinion for a proper constitutional conclusion against racial segregation. All right? Had the Chief Justice perhaps chosen to focus more on the history behind the adoption of the 14th Amendment, a solid legal argument against school segregation could have been based solely upon that very history and the intended scope of Section 1. However, he deliberately avoided direct confrontation with that history by labeling the intent of Section 1 largely uncertain, and instead focused on just how much public schooling had changed since 1868 when the 14th Amendment was ratified. Because of its evolution, it was impossible in Warren's mind to discern how the framers of the amendment would have felt on the subject. Considering at the time of the adoption of the 14th Amendment, public schools were certainly nowhere near on the level of what they were in 1954, and not even remotely close to what it would be in 2021, all right? A vast majority of people, especially in the South at that time period, were educated privately, all right? There was no real rigid system of what we know of today as public schools in many states, okay? What you have today is wholeheartedly different than what you had in 1868 and to even to a minor extent in 1954, all right? But definitely in 1868, you know, there was nowhere near what you would find today when it came to public schools, all right, especially in the South. Northern states had a more organized system of general public schools, but in the South, my gosh, that was a rare bird, all right? And this is where the focus of the amendment obviously would have been aimed, though it, of course, would have been nationally applicable, all right? But, all right, So again, because of the evolution of the times, it was impossible in the Chief Justice's mind to discern how the framers of the amendment would have felt on public schools, all right, and segregation. This was Warren's gateway to using a more modernist approach to constitutional interpretation and the use of data to defend his opinion. In truth, the Chief was splitting unnecessary hairs by zeroing in on how much public schooling had changed in the past century between 1868 and 1954. Because guess what? Everything else had changed too. Why was public schooling anything special? Therefore, one must ask, what did it matter how much public schooling had changed? The 14th Amendment speaks in broad terms, not focusing on any particular institution. It did not matter how much schooling had changed since the amendment's adoption, because the words of the 14th Amendment were the same in 1954 that they were in 1868. Those words required the same thing in 1954 that they required in 1868. Legal and social equality, that is my argument. Even if Warren wanted to fixate himself with the changes in schools and in schooling in general, per se, all he had to do was refer to the congressional transcripts of April to June 1866. This would have been his solid basis on how the amendment was overwhelmingly designed to outlaw all racial classifications in public life, schools, and the like. The framers sought race-neutral laws, and racial segregation is obviously race-neutral. As the language of Section 1 was articulated by its authors to build a bridge of harmony between the black and white races in the states, then school segregation, or segregation anywhere else, would be entirely unacceptable. Legal and social harmony were two halves of the same walnut in the 14th Amendment to bring together the races on the same field of equality. Though Warren stated in Brown regarding the reaches of the 14th Amendment that at best they are inconclusive, the evidence kind of stands to the contrary of the Chief Justice's statement right there. The historical testimony presented in this essay is pulled directly from the congressional debates of 1866. It shows just how clearly Section 1 was designed to outlaw racial classifications in the states. This was applicable whether the classifications were legally or socially oriented. The Chief Justice concluded by saying that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Knowing the history of the 14th Amendment, this is basically stating the obvious, though it was quite necessary in the context of the decision in 1954. Separate facilities are unequal from the ground to the ceiling. If one is separated, how are you equal? The virtue of separation indicates we're not equal. All persons in the states were to be subject to the same laws, prohibitions, and accesses. That is what the concept of equal protection means at its heart. And no separation of the races can logically be squared with equal protection, even if the Plessy Court in 1896 said to the contrary, even if the separate facilities are equal. Sorry, that does not rest well with the language of the 14th Amendment. Equal is not allowed to be separate just because the facilities may appear to be on the same playing field. I can't separate person A and person B, all right, merely because of these unchangeable external factors, all right, and force them to use these separate facilities and claim that these two guys are equal. Obviously, if we're making them use separate facilities, they're not equal, folks. All right. Some thought, it to simply guarantee legal equality alone. But among the men who wrote the 14th Amendment, those individuals were minority voices. The crafters, for whom the greatest weight should be assigned, Thaddeus Stevens, John Bingham, Jacob Howard, all right, spoke of the amendment in broad and encompassing terms, not limiting ones. They wanted it to touch all areas possible to eliminate the pre-Civil War animosity between blacks and whites, and to give blacks a chance to truly be able to have access to the American dream. Okay? The radical Republicans, wanted to create a nation of one people, no longer fractured by racial divide. It was a lofty goal that we still haven't attained. These men were not called radicals because they sought moderation, calm, or compromise. Instead, they sought revolutionary change to the legal and social order of the United States of America in general. How then could they still have the desire to permit racial segregation in spite of the amendment's inclusive and egalitarian words requiring equal protection? The answer is quite simple. They could not. So, I thank you for listening to this essay on constitutional originalism and the Brown versus Board of Education decision. My point, of course, being argued that the majority opinion in Brown could have been reached without the use of socio-scientific evidence or data of any kind, but rather from a plainly originalist interpretation of Section 1 of the 14th Amendment, requiring equal protection of the laws, for which racial segregation does not in any way square with equal protection of the laws. So again, I thank you for listening to this. If you have any questions or controversies, leave them down below. I'll be happy to answer them. If you made it this far all the way to the end, give yourself a pat on the back. You're a strong person, or you must really like this subject as much as I do. Okay? If you liked this video, enjoyed it, learned something, please drop me a like on the video. It would be greatly appreciated. And if you've not subscribed up to this point to my channel, Warrisley Shelton MA, please do so now. That means more than you will ever know. All likes and all subscriptions do indeed matter. Okay? So I thank you for listening. Take care. Stay safe out there. Be blessed. And I'll talk to you at the next bite. Peace.